Well, good afternoon from London, but also good afternoon from Warsaw. I'm delighted to have Marek Oleksyn back with us. Eric, you may remember Marek spoke with us last year about e-signatures, and today he's going to be looking at AI-made inventions and AI-created works in Europe. What does this have to do with my business? Now, many of you will know that I'm a bit of a pedant, and I keep saying it shouldn't be called AI, it should be called machine learning. But today I'm going to relax, break the rules a little bit, and we're going to have an exploration because what Marek has done is to tease out a very, very interesting issue, and one that we in the UK, oddly, might be slightly behind on. And you'll see in a minute what I'm talking about. Meanwhile, you'll know me. I'm Michael Mainelli. I'm one of the directors at Zen, and it really is a privilege to be able to introduce so many fun and fascinating webinars. But I can only do so thanks to the tolerance, and really I do mean the tolerance of our sponsors, who allow us to range widely and freely across technology, economics, and finance. Now, as many of you will know, one of the greatest battlegrounds, probably of the 21st century, is looming out to be very much patent warfare, trademark warfare, design warfare, and we're seeing a huge area there. Xian was very involved in this in the creation of the Global Intellectual Property Index. But one of the things that we've found over the years is that people are now interacting in so many different ways. Uh, Lawrence Lessig at Harvard made a comment that these days the only film that you could shoot legally is basically two naked people in a white room. And that this is one of the difficulties. Intellectual property rights are becoming more and more confusing. And we're going to let Marek range widely and freely across that in a moment. But just before we do so, three quick points of housekeeping. Firstly, yes, the slides will be up. In fact, I believe are up on the chat room area for you, thanks to Peter, who's in the background producing this session. Secondly, we will be having the recording up in approximately 2 working days, so it should be up probably late Friday. And again, available and fun and free to share with colleagues and friends. But lastly, questions. We really would like some questions for the question and answer session, and this should certainly generate quite a few, and maybe some interesting examples from all of you. But questions, comments, and observations through the GoToWebinar facility, please, because I'm here with you. So if you text me, signal me, WhatsApp me, email me, that's great. I love hearing from you, but I won't be able to feed them into the question and answer session with Marek. Marek will be getting all of the questions and answers with your questions or with your emails attached. So if you want a point of detail or get back to him, just stick it in the chat room, and I make sure that he gets it just a bit later on. But anyway, at this point, Marek, over to you. The floor is yours.
Thank you. Thank you very much, Michael. Thank you for so warm welcome. And I'm very happy to be with you and with the attendees again. This time, I'm delighted to present one of the, let's say, most hotly debated topics in the IP field, which is inventions being made by and works being created by artificial intelligence or machine learning tools. So I'm happy to. Right. I'm still learning about that. And speaking of which, actually, this is a good startup for our discussion because when we discuss inventions being made by machine learning algorithms or deep learning algorithms or works being created by artificial intelligence as such, there is always some kind of tension or discussion around what should be understood as artificial intelligence as such after all. And without going into a detailed discussion on this point, I think it is worth noting that we have like quite a fresh approach right now, at least from the European Commission, because after, let's say, different approaches and different understandings being presented by legislators, by legal authorities, by scientists, there is this fresh broad proposal from European Commission for a definition of artificial intelligence system. It was set up in the artificial intelligence regulation, which was proposed most recently in April this year by the EC Commission. And according to this document, the Commission proposes a very, very broad understanding of what should be considered an AI system. And they propose that it should mean software that is developed with one or more of the techniques and approaches listed in annex to this draft regulation, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. And until now, there was not so much controversy behind that, until we have a look on the Annex 1 to this regulation, where we can read what kind of AI techniques and approaches the Commission has in mind. And they are indeed broad, because they mention not only machine learning approaches, like supervised, unsupervised, reinforced learning, using a wide variety of methods, including deep learning, but also logic and knowledge-based approaches, which include knowledge representation, inductive programming, knowledge bases, inference and deductive engines, or reasoning and expert systems. But what is more, they also put into the same basket statistical approaches, Bayesian estimation, and search and optimization methods. I think it's we are at the fourth day of quite important and interesting discussion about the common understanding and the common legal understanding behind artificial intelligence, and this may also impact the key points of our today meeting, which is inventions and works being created by AI. So yeah, we can go ahead. And
Well, that's a great one, though, Marek. I think, though, that they've at least answered my question for the first time on AI. AI is everything in Annex I.
Absolutely, yeah. That's a very good approach, and I think you are not the only one who thinks about it this way. And we'll see what will come out from this draft regulation and which version will be final. So let's see. And as regards artificial intelligence as inventor, we thought it would be a good moment to start with an interesting poll for you, just to check your approach on inventions being made by AI. And here's the question, which we would be very happy to hear your view on. Do you think that patents for inventions made exclusively by AI algorithms? So answer one, should not be granted at all. Answer B, may be granted to AI or its legal successor, or perhaps you would think that may be granted to the owner of the AI algorithm.
Great. Well, that poll's been launched, and as you know, Marek, from previous experience, our audience is very fast on the trigger, and well over half have voted. I'll leave this poll open just a few seconds longer. 3/4 of the audience have voted. 80% have voted. We're well over the 80% mark. There we go. And I'm now just going to close that poll and share the results with everyone. And basically, over 60%, nearly 70% saying may be granted to the owner of the AI algorithm.
That's very, very interesting. And thank you very much for your answers and for your thoughts on this. And I think that thank you also for very fast reply. It was as fast as the European Patent Office provided in its recent decision, which I'll point in a second, concerning Dabus invention. Perhaps you have heard about that. But as a starter, why this aspect is for us and for the business important at all, and a question is whether it's not just an academic discussion behind that, which is devoid of any legal or practical relevance. And the answer for this is it does matter, because inventions open a way to patent, which means monopoly throughout certain territory and in a given time period, and it provides a very good tool for competition advancement on the market. But in order to get a patent monopoly, certain requirements must be met. They are typically the same in every, let's say, modern jurisdiction. So an invention must be new, must have an inventive step, and must be of industrial application. But also, that's one of the very important formalities when you file an invention for patenting, wherever it happens, either before the UK Patent Office, before the European Patent Office, the Polish one, or any patent office in Europe or in the US. When you file a patent application, you must indicate an inventor. And as an example, under the UK Patents Act, a right to apply for a patent is vested in every person being an inventor. An inventor in relation to an invention means the actual deviser of the invention, where a joint inventor shall be construed accordingly. This is very interesting because under the UK law, for example, there are two prerequisites which must be jointly met. Such an inventor, deviser, must be a physical person, and he should indeed contribute to making the invention. So that's interesting, and we can have a look on the next slide about some key points which were posed after most recent, let's say, case law developments, whether it is necessary to indicate the inventor in the patent application. Can the artificial intelligence system fulfill the conditions of being any person? And what if the actual designer of an invention is not a human? So these are very important practical questions. And the last one, perhaps the most important, is whether there are any regulations behind those questions which would provide answers. And this answer is yes and no. And why, you can have a look on this slide, and which provides some background behind European patents, where a European patent application may be filed only by a natural or legal person on any body equivalent to legal person. But what happens if this applicant and this natural person is not the one which should have been introduced in the patent application? Such a person can request that a European patent application is refused in case it turns out that a wrong divisor was set out in the patent application. So this is important because it may impact not only the procedure of granting a patent for invention as such, but also its later validity. And what is more, and that's some piece of information on the next slide, is that under the European Patent Convention, this European application must designate the inventor, and also it must designate his full name and address, which I think provides some answer as regards to whether AI as such can be listed or indicated in the patent application as an actual inventor. But let's have a look on the next slide as regards the practice before the European Patent Office. Very, very interesting case by Dr. Stephen Taylor from the US, who filed several patent applications for his two inventions. It happened before the EPO, it happened before the UK Patent Office, and before the US Patent Office. In all these three forums, patents were rejected. And before the EPO, it was stated that the applicant cannot be indicated as an artificial intelligence like Dr. Taylor proposed, and inventor designated in the application has to be a human being, not a machine. It was very interesting because Dr. Taylor, both before the USPTO, the UK Intellectual Property Office, and before the EPO, he mentioned that if he had not shown AI algorithm, this DABUS program, as the actual inventor, he would mislead the public. That's why he did it, he said. And his contribution to this invention was next to none. So that's why he wanted to be fair with the market. But eventually, EPO refused granting this patent for those two patent applications. And as you can see in the UK IPO formalities manual, it was updated after this case, where AI inventor was said is not acceptable, as this does not identify as a person which is required by law. The consequence of failing to supply this is that the application is taken to be withdrawn, which is very interesting, and which of course will impact the situation where such patent would theoretically be granted. So we can have a look on what happened before the UK, England and Wales High Court of Justice. The same two inventions were refused before the UK IPO. So it was appealed, and most recently, September last year, there was a judgment issued by the England and Wales High Court of Justice, where Mr. Justice Marcus Smith mentioned that he's behind this general rule that the owner of a thing is owner of the fruits of that thing, and consequently, the owner of a fruit tree will generally own the fruit produced by that tree. He further said that it is quite impossible to say that simply because Dabus, this AI algorithm, has invented something and Dr. Taylor owns Dabus, that Dr. Taylor is entitled to grant of a patent. So he further elaborated, saying that there must be either an application by the inventor within the relevant sector of the UK patent law, and Dabus cannot be such an inventor as it is not a person, or the inventor must have transferred the right to apply, enabling Dr. Taylor to apply under one of the sections of the patent law. So this was a long-awaited judgment of the UK court, and the decision of the UK IPO was upheld in this case, very similar to what has happened before the US PTO. And for sure, I would say that I consider that the decision grounded and justified based on the current wording of the relevant regulations. However, it indeed called for action as regards how we should approach and how we should assess inventions being made by artificial intelligence. So when we shift to the next slide, we can see why this discussion is important from practical perspective and from business perspective, and not just a purely academic point to discuss in universities, because it indeed will have impact on the business. Because when you have a look on the question, what happens if a human is no longer a designer under, for example, the UK IPO approach to the extent sufficient? So, for example, if it just fed the AI algorithm with some of the data, but did not contribute in an inventive way to this final outcome of the invention made by the AI. And for example, if such an invention could be perceived as made jointly by the AI algorithm and the person who worked together with this AI algorithm, both on the input and or on the output phase of the invention creation, then there are very practical and important questions as to whether a human being can indeed perceive himself still as an inventor or as a patent applicant. Because it may happen that even though on paper everything is correct under the relevant laws, then a year or 2 years later, it may happen that it turns out that his contribution to invention was slight and he did not qualify as an inventor for this particular invention, and the patent perhaps should not have been granted at all. And what is more, it will also impact the ownership and subsequent effective assignment of such patents. For example, when you have a transaction or M&A transaction where patents are the key assets of a given business. But what is more, if it turns out that inventions, as some of you have answered, being made by artificial intelligence do not qualify to be patented at all, then of course it will impact the business strategy of innovative businesses, where they may come to the conclusion that no longer they should be shown to the public. Rather, they should be kept as a kind of black box and kept as a trade secret, rather than making any patent attempts, because you will need to make a disclosure to the public, whereas keeping it as a trade secret would still secure your business advantage. So those questions are very vivid. They are very widely and hotly debated right now and discussed. And as you may see, there are lots of possible approaches how to solve the problem. So for example, one option is to redefine the inventor, saying that it should be a person, but his contribution, innovative contribution, does not to be that high. On the other hand, we may say, take a very, let's say, futuristic approach and say that AI can be indeed an inventor, which is not the case right now under the current regulations. And also, perhaps, there should be a new specific group of inventions under the European Patent Convention, under the UK law and the European countries' regulations on patents, which would create a new category of inventions being made by AI, where a human as inventor would not to be indicated. So these are some proposals right now being discussed, and we should, I hope, shortly see some results. And right now, skipping to creation and works made by artificial intelligence, we would also try to start here with a poll for you. You can have a look on it on the next slide. You can see a painting from the next Rembrandt project. As you can see on this slide, ING commissioned an AI project that created this 3D printed Rembrandt painting that experts agree would be his work. It was completely unexpected for the people involved in this project. It was completely created by AI. And here is a question for you. As regards copyright to this AI-created painting, who holds the copyrights? Number one, it is not a copyrightable work at all because it was not created by human. Number two, no one can copyright this work, again, as it was created by AI algorithm. Number three, persons who are co-authors of the AI algorithm. Or perhaps number four, an entity that ordered the work from people who used the AI. Okay, I hope you are able to make your vote. So, oh, I cannot hear you. Okay, very, very interesting results. So yeah, fantastic outcome of the poll, which may show how important this legal topic may be in the nearest future. So as you can see, our votes are very equally divided, and there is no easy answer, and you are absolutely right in making different in choosing different paths in this, because let's start, for example, with the Singapore Court of
Yes? Just say, one of the things that was interesting was on this poll, you really stumped them. It's very rare this audience has difficulty making up its mind, so I had to leave it open a lot longer than average. And secondly, the early answers were all about it is not copyrightable at all. But as you'll see, they moved heavily over time to the third answer, the persons who are co-authors. So it was a very good question.
Thank you very much, and thank you very much for your answers. And what I was thinking behind those questions is that indeed there is no an easy answer behind that, because when we have a look on this next Rembrandt case and some views of the lawyers so far, it was not anyhow decided by any court right now, but the general point of view was that indeed this should meet the threshold of copyrightable work as it is original and it is fixed on some tangible carrier. So it meets the criteria of copyrightable work. But since a creator cannot be considered an AI algorithm, then we should either vest copyright with programmists, art historians who participated in the project. There are like 20 or 30 persons overall taking part in this project. Then they should be considered co-authors. But then again, there is not an easy answer whether each of them has contributed in a creative way finally to this final project and this painting. And the proposal from the lawyers was that ING should be vested with copyright, as this copyright would be considered a specific type of work made for hire, which under the relevant rules would be transferred directly to ING. But in this particular case, there was no question between the lawyers that this should be considered a copyrightable work. On the other hand, however, when you have a look on this Singapore Court of Appeal case issued in 2019, I think, or 18, by the Court of Appeal in Singapore in a case between Global Yellow Pages and Promedia directories. There was a dispute behind whether a compilation of Yellow Pages or phone books made by artificial intelligence algorithm without any piece of human participation should qualify as a work or not. And the answer before that court was no, it is not a copyrightable work because there is no this human creativity aspects behind that, and it should be deprived of copyright protection at all. So it's very interesting. We'll see whether there are any new interesting cases behind AI created works. But as you can see, we can have algorithm of artificial intelligence be considered as a painter, as you could have seen in Next Rembrandt case, as a writer in DeepSpare automatically generated news, as a composer, which you can see behind the Flow machines, a very interesting project, by the way, or for example, as a designer where AI designed a book cover for the AI age, and finally, a director or performer. And again, we have plenty of open questions and open point behind that. So whether this should be granted copyright protection at all, who should be considered the author, and how about the term of protection and enforcement of copyrights in case we come up with to the conclusion that perhaps AI should be somehow granted any copyrights. So just to sum up our discussion, I was thinking which interesting quote from the past would match with our today discussion. And when I found this one, I thought it would be very interesting for you, because I think that perhaps Friedrich Nietzsche did not even have any kind of similar thoughts in mind when he said that our writing equipment takes part in forming our thoughts. But it looks like that based on the current regulations we have in force in Europe, for sure, indeed, we should consider AI algorithm rather as a kind of tool based on which we as humans make inventions and create works. But of course, it's not obvious, and of course, we may expect some upcoming changes in this respect. So thank you very much for your time. I would be very happy to here to see your questions and try to answer them as well. And I hope it was interesting.
That was excellent, Marek. Thank you very much. We've got lots of questions and comments, and I think this is a bit more of a kind of an observation session than it is a definitive legal advice, as you pointed out here. In many ways, I'm reminded of the old Escher picture where one hand is drawing another hand. This is the sort of area that we're in. And I can almost imagine in some of those science fiction short stories I read as a kid, Asimov and others, you're looking at this concept of can the AI own itself, and a number of basically recursive issues here. Might just start with one. There are quite a few here. Ian Waddy makes an interesting point that you could, I think, comment on about the owner of the AI algorithm. So in the example that you gave on the Rembrandt, you were looking very much at the audience came down very much in favor that ING owned it because being FS Club, they followed the money. And so they said, well, whoever pays owns it. But Ian's kind of curious, is it the originator of the algorithm or the person wielding the algorithm for the particular use case? Any thoughts on that?
Yeah, there was a debate behind that, whether which persons, if I understood the question correctly, which persons behind the AI algorithm should be considered authors, right? So there was a discussion behind that. And indeed, the question is very good because it is uncertain whether each and every programmist who contributed to development of this AI algorithm, but also other people like art historians and other contributors, not necessarily creators of the AI tool as such, should be perceived creators of the final outcome and the piece of work made by this AI algorithm. There was no, let's say, decisive answer to that, but the proposal was that with respect to each of those co-authors, respective tests should be performed, whether he contributed in an original way to the final outcome of the AI work. So in other words, whether his contribution was purely technical or whether it was more creative, so that he should be considered co-author, which is anyway very interesting, as in case you have a look on the different approach on either patenting or protecting as copyrights AI algorithm as such, which is also another huge point to discuss, for example, between the US approach and the European approach, where we protect copyright, where we protect software through copyrights, not patents as such.
Just following up on that, Ian had a couple of other points. This is Ian Waddy again, about that creativity point. So supervised learning is directed at a task by a person. Unsupervised learning is a classification technique. What are your thoughts? Is AI actually capable of original thought, or is that restricted to persons? And he gives an interesting point here. Can a mathematician be creative?
Mm-hmm. Yeah, that's a great question with, let's say, again, unfortunately, not an easy answer behind that, because and it touches upon the first slide we had, where the proposal for artificial intelligence is extremely broad. It wasn't expected to come like this when the proposal was awaited, especially given the very broad variety of techniques which are being considered as contributing to AI. And it's even more interesting that when you have a look on the considerations made by the high-level group before the European Commission earlier, they focused very much on the rationality of the AI system to come up with certain solutions based on what they are fed from the environment. And this threshold of rationality was the key element when deciding whether we deal with artificial intelligence or not. And right now, it is being said actually that in Europe, we will need to consider AI actually every piece of software, even if typically, and by scientists and experts, this should not be considered artificial intelligence at all. But this is very interesting, especially when you have a look on what consequences will be applied to operators of artificial intelligence in such broad understanding.
Bob McDowell and Trevor Hilder make some interesting points. Bob first, he's looking here at, can AI be granted personality? Not according to current legal principles. But the issue should clearly not be left to the judiciary, in his opinion. Any determination on legal personality has to be left to the legislature, he would argue. Trevor Hilder makes a lovely point. Trevor, well done. Apparently, there was a contention in India about the legal status of gods and goddesses. And the British came up with a solution, of course, which is that they are considered to be legal minors. But what is the status of AI potentially as personality?
Yes, that's another very good question. And there was a discussion, I think, and that paper was prepared by the European Commission or European Parliament about that. It was quite, let's say, comprehensive and detailed in its scope. And eventually, right now, so business as usual. So both machines or AI algorithms are not considered to enjoy or to be vested with legal personality as such, for many different reasons. And the main point behind that is we could not, let's say, make a clear change of law in order to provide or to vest artificial intelligence or machines with legal personality, because the whole civil, at least, regime in Europe would collapse, and there would be plenty of unanswered questions concerning liability for damages, for example, caused by such AI algorithm or a machine with AI algorithm having a legal personality. about transfer of ownership, about having judicial capability of bringing claims and so on. So until now, it is said that although this concept is very interesting, for example, also in terms of pointing AI as an inventor for invention, but there is no concrete proposal right now to make any changes in that respect, at least in Europe.
Well, back in India, Trevor Hilder, just as an aside, points out that Indian gods and goddesses own trillions of dollars worth of assets through their trustees. The temple's full of treasure. So, very interesting. Thank you so much, Trevor, for that. Um, uh, Moving along on that line, just a little bit further, back to Bob. Bob says, the companies have been endowed with legal personality, but they can be wound up. So, if we had sort of a vehicle like that, how does one terminate the life or personality of an AI? If an AI actually had a legal personality, what would the process be for destroying it?
Okay, yeah, that's a good approach, yeah, and a good argument, I think, which is not that easy to counteract, I would say, because when you have this theoretical concept of legal entities, then indeed it may as well be used to discuss in detail the concept of legal personality for artificial intelligence. On the other hand, we know that this legal concept in Europe is, let's say, some kind of contractual, a kind of arrangements between persons saying that at the very end, it is the management board or a supervisory board, which consists of human beings that make the decision about what the legal entity will do or will not do. And for this reason, it may be an argument to somehow distinguish anyway legal entities from another theoretical concept as artificial intelligence. But that can be used as a very good argument for discussing legal personality in the future being granted or being vested to artificial intelligence algorithms.
Okay. Got an interesting question here as well about really competence. But let's go to what is the status of improvement patents in the AI context? Meaning, if an algorithm is invented by an individual human, what happens to an improvement made through machine learning without further human intervention? Can that improvement be patented? And that's via Hugh Purser.
Mm-hmm. I would say that's a very good question, and I would say that so far they should be considered inventions being subject to being granted a patent right, as long as the prerequisites of novelty, inventive step, and industrial applicability are met, and there are no, let's say, rules which would prevent this improvement from being patented, even in those circumstances which you have outlined right now, unless in the future it will turn out that a person being indicated as the author, as the inventor, as the designer of the invention did not have any inventive input whatsoever in this improvement, and somebody would like to take benefit out of it and try to attack the validity of the patent based on false information being provided at the stage of filing invention for patenting.
Okay. We've had a couple of questions from a variety of people, so all along the same lines. I won't name check everyone, but Ian Waddy again, and I think Scott Bryan and a few others. And it's basically about autonomous vehicles, the liability thereof, current property law, things like that seem to be moving in this area. Who would be responsible in the event of an accident? The owner of the car, the creator of the car, or given this discussion, the creator of the AI algorithm?
Yeah, and that's actually that's a great question, and I think that's actually absolutely within the scope of the most recent papers proposed by the European Commission, where simultaneously there was this AI draft regulation and machinery regulation, which will deal with specific risk-based regimes behind using AI in different types of machines or devices, and it will basically be based on 4 different types of level of threat with which AI can cause. The first level is just neutral. There is this insignificant scope of risk caused by artificial intelligence, like chatbots, for example. But the third level is a high risk level where very specific rules would need to be observed by the operator of the AI on the market. And on the fourth grade, we have this unacceptable risk, artificial intelligence, which impact human behavior in a way which is not acceptable by the legislator. And coming back to your questions, again, this would be considered on a risk-based analysis, whether and to what extent the operator of the artificial intelligence being used in autonomous vehicle will be liable for damages caused by such vehicle.
We've got time for just two more questions, really. Edwina Morton makes a point, and I think where she's driving at this is why patent at all. The idea of not applying for patents in order to protect intellectual property is not new. I once attended an event with Brompton Cycles where this was explained. They knew that their IP would be mimicked in countries that do not have reliable patent procedures. Does this sort of problem not also apply in spades to AI invention? And I must say my personal view over many years has been just not to patent this sort of thing and to stay away from it where possible. So any comments about that as a strategy?
Absolutely, yeah, that's a strategy, and it's always a strategy regardless of whether AI is behind an invention or not. And I think it's even more important right now because when there is any kind of doubt behind whether making a disclosure for patent would be unsuccessful eventually because it would be either not granted or invalidated because of the, let's say, questionable offer behind the invention, it may even more encourage business to keep it as a black box and protect it as a trade secret as long as it's possible and as long as reverse engineering cannot apply, and protect it as a trade secret in different tools and devices where AI solutions are embedded.
Well, I'll conclude on a kind of a double question, which fits together neatly. Bob McDowell again, but along with Scott Ryan, if I might put them together. Bob is, how competent is the EU in addressing regulation or practice in this area, given the velocity of development? And Scott wonders, really, what do you think are the prospects of actual legislation coming out of the EU? In his opinion, it just seems an attempt to jump on a bandwagon they don't understand.
Yeah. I can concur and I can agree. I've read the information behind proposing those papers on the EU level, and the idea is, let's say, a kind of need or a wish to make Europe a leader in development of, let's say, responsible artificial intelligence. So not only to speed up the process as such, but also to make sure that, unlike in any other region as of now, for example, the use of artificial intelligence will be ethical and safe for human beings, where human will be in a center of the whole project. So that was the idea. But again, indeed, there are lots of voices which say that it's another example where not necessarily the views of the experts and the views of the technicians were sufficiently taken into account, were proposing very far-reaching legal instruments behind the use of AI. But lots of lawyers right now, for example, and the business says that this project will be very discussed in detail before the European Parliament, and it may happen that it will be substantially changed before it reaches its final version.
Wow. Well, we've covered a tremendous amount of ground, very thought provocative, and really thank you so much, Marek. I've got 3 quick rounds of thanks. Firstly, very much to our sponsors who allow us to cover these subjects, but very clearly we're going to be looking at software creating software, and that certainly features enormously in every area to do with technology, economics, and finance. And I myself am really quite curious. You look at this, and I started my early career in CAD CAM, and just to take AutoCAD as one of the early folks in that space, if every architect and designer in the world said that really they had a hand in this, but AutoCAD came in and said, no, we provided the ability to do it, a bit like the design software you showed earlier, that would be crazy. And don't forget, of course, the recursive circularity here. Trevor Hilder has given up on Indian gods and goddesses, but he has obviously elevated the judiciary to the status of deities. He says, how about when AI judges start making legal pronouncements? Anyway, the audience today, as well as our sponsors, have been superb. Really thought-provoking questions, folks. Most enjoyable. And just a reminder, tomorrow morning we have a very special event with Sir Vince Cable. And I'd encourage you to sign up for it at 9 o'clock. We're going to be talking deep about UK-China relationships. So if you have a genuine interest in China, by all means, join this fairly exclusive discussion group tomorrow morning at 9. And as ever, the rest is on the website. But my sincere thanks need to go to Marek, who constantly surprises me with the depth of his knowledge as a lawyer about what matters in not just e-signatures today. All right. I won't call it machine learning, artificial intelligence. And it's been really, really super to have you, Marek, and we hope to have you back again sometime on another one of your specialties. But I need to now use physical devices, not software, to say thank you. So I have my Korean karmic clapper. We thank you sincerely. Take care.
Thank you. Thank you very much, Michael. Thank you, everyone. It was a great pleasure. Take care.
Really good
Thank
to
you.
have you.
Bye-bye.